Good evening, everybody. Thank you guys so much for attending tonight. My name is Zach Burke. I'm with Elite Management Services. With me tonight, I've got our owner, Dan Donahue. And then with Kaman and Cusimano, I have Maggie Myers, a partner who specializes in collection efforts and foreclosures throughout Ohio and West Virginia. So from here, we are going to just let Maggie present. As well, ask everyone if you can keep yourselves muted and your cameras off throughout the meeting. Very appreciated. And hold all your questions until the end. You can send your questions in through chat or hold until the end, raise your hand. But after we get through the presentation, we'll start taking questions. So Maggie, I will hand it over to you. And thank you so much.
Thanks. Hi, guys. Hello, everyone. It's great to see people. Thank you for having me. I'm really excited about it. Thanks, Zach. Thanks, Dan. So like Zach kind of mentioned, I will certainly be able to hopefully answer any questions you may have. If you are a client of our firm, I can probably provide more specific legal advice, but if you aren't a client of our firm, just know that this is all general advice. Wow, I was immediately muted by the host. So far, so good. It's okay. So anyways, just know I can give just general advice if you are not a client. So that's kind of what I'm sticking with today, is just more overarching general collections issues, our process, our recommended process. But of course, if you have any questions I can answer, I'm happy to do so. So to back up and introduce myself a little bit more, my name's Maggie. I am a partner at Kaman and Cusimano. I am in our Cincinnati office. I am licensed in Ohio and Kentucky, actually. Thankfully, West Virginia would be much harder, I think. But so I'm a licensed in, I almost said West Virginia, in Ohio and Kentucky. What I'm going to talk about today is mostly Ohio related things, but a lot of the same provisions apply in Kentucky. Of course, if anybody here is from Kentucky, let me know, and I'm happy to answer those too. Let's see. Oh, is my Kaman and Cusimano backwards? Huh. Not going to even try to fix it. Just know that I am technologically challenged. But what we'll do is go ahead and get right into it. So again, like
Zach, looks great.
Oh, good. Thanks. So like Zach mentioned, I am a partner at Kaman and Cusimano. I primarily, however, focus on collections. So our firm, all we do is we represent condominium and homeowners associations, community associations throughout Ohio and Kentucky. And we're all community association attorneys, but some of us, we all specialize in different areas of community association law, and collections happens to be my bag. So it's my passion for community association law. So that is primarily what I focus on. I am also our director of Southern Ohio and Kentucky collections. So obviously a big thing to me. Collections in general is so important to me, and it's such a big thing for associations for a number of reasons. I mean, your assessments fund everything that you need to do as a community, vital aspects of your community, landscaping, maintenance, insurance, the legal fees that you have to pay. Your assessments fund all of that. And so, especially today, we're all operating under tighter budgets with inflation. And so, you know, if one person doesn't pay, the rest of you have to make up the difference. And it's absolutely unfair. So collections has a special place in my heart. So since we only represent community associations, I think over time we've been able to kind of develop and fine tune a really successful collection strategy. You know, multiple strategies, but a really successful collection strategy to really combat the problem. It works is the biggest thing that I found over my time here. It definitely works. For example, so in little self brag here, in 2021, throughout our firm, throughout our entire firm, we were able to collect, it was over $11.5 million for all of our clients. That includes legal fees, late fees, assessments, enforcement assessments, processing fees, anything that you can think of on these accounts. So that I just think speaks volumes to the process. We do have I think it's about an 85 to 90% collection rate, meaning you get paid in full for everything on that. So I truly believe that this process works. Before we kind of get started on all of this, I think it's important to understand overall what the goals of a collections case is, what the goals of collections in general is. And really, I think there's two. Number one being collect the most money as much as possible, as quickly as possible. And then the alternative side of that is also, you're also trying to stop the bleeding of bad debt. So like I said, 85, 90% success rate. There are some of those cases that you can't get. Maybe we're not getting paid. Maybe we're low enough on the totem pole. Maybe these people are uncollectible. The bottom line is you need to be aggressive so you stop the bleeding of bad debt and you get a new owner in there that's going to pay the assessments moving forward. So those are the two kind of goals that I like to think about when I think about collections. And to accomplish those goals, we advocate a really aggressive policy and procedure. So what we do when we get started is when we get started with a client is we will work with each association. We work with each individual board and we draft a customized collections policy and procedure that you can implement. You as a board can adopt it. It doesn't need an owner vote. You can adopt it yourselves and then we implement it. We do it so the process is streamlined, but also so it's fairly applied, so you avoid discrimination claims, and it's just a very objective approach. So once that's adopted, we work really closely with your management company. So we work with Elite very, very closely to really implement the strategy. So they send over monthly delinquency reports. I'll review them each month and take the necessary action as explained in your policy and procedure. So that's kind of how the operational things happen. In general, again, I said I can't give really specific, so you're gonna hear me say in general every 5 minutes. Sorry already. In general, though, for condominium associations or monthly fees, any associations that have monthly fees, my policy that I usually recommend is I send an initial letter, which is called a validation notice, at 2 months behind. And then I recommend filing a lien at 3. And then around 5 months, if they're still behind, none of those letters have worked, I'm at the point where I'm recommending that the board review and approve foreclosure. So it seems very aggressive. Again, it depends on each individual association. You may be a monthly client, but you may have, assessments that are $40 a month. That may be a little bit longer than 5 months, but like I said, we work with each individual one. We'll tailor it to your association. But for the run-of-the-mill condominiums, that's typically what I recommend. For HOAs, or condominiums, if you're an annual fee or semi-annual or quarterly, whatever you are, we truly go through everything and we'll customize it. But typically the steps are the same. It just depends on, there are additional steps, of course, but it just depends on your association's needs. And that's why we customize them, just because it is so much more effective that way. So all that being said, when I said the steps are the same, there's a litany of things that you can do to collect, right? But the 3 that I talked about, the letter, lien, foreclosure kind of thing, I'll talk about all of our different ones that may be included in your additional policies. If you've got a small claims case or something like that, maybe post-judgment, but I'll get into all of it. I'm going to put everybody to sleep by 6:30 is my goal. So I'll talk about all of those, but I think it is really important to mention before we even get into these things. A lot of times I'll have boards say, hey, this person missed their first payment, or they missed this monthly payment. Let's just foreclose. Love the attitude, love the go-getter attitude, but there are certain laws that we have to follow. We're subject to the Federal Fair Debt Collections Practices Act. There are certain Ohio and Kentucky revised statutes that kind of dictate when and what you need to do and procedural aspects and when you can send something next. So all of these policies are drafted while reflecting any requirements we have to do on our end to make sure we don't violate any fair debt rules, which is a great thing. So for example, there's a lot of things that we have to do before just jumping into foreclosure. Okay, so actually in November of 2021, the CFPB just adopted a new regulation to the Federal Fair Debt Collections Practices Act that now requires any debt collector, or so us as your debt collector, the association as the actual debt holder, we have to first send what's called a validation notice. We used to send collection letters is what we would call them. It's kind of just a demand for payment, but we're just saying this validation notice is really replacing that in our step if you've been a client of ours. So that's what I'm talking about. The validation notice is basically a form that gives the debtor the information, how they can pay it and how they can dispute it. And then it also extended their dispute period from 30 days to 40. So that's definitely not great, but it is what it is. So we have that hurdle to jump before we can even file a lien. We have to wait the 40 days after we sent the validation notice. Once we do file the lien, which you're filing a lien to be able to, it clouds title. It's a document you file with the county recorder, and it clouds that owner's title. They cannot sell, refinance, do anything with their property until it's paid. They can't transfer clear title to someone. And it also is the method on which we foreclose. So we cannot foreclose without a lien. You're foreclosing on that lien. So that's what you have to file first. Once you file that lien, and once it's recorded, now Ohio requires that we send what's called a statutory notice. It's just a notification giving them a copy of the lien, what the debt was as of that date, and really just debtor friendly, giving them the information. You have the right to file bankruptcy. You have the right to do X, Y, Z, but that is required by Ohio law. And then that's a 30-day dispute period. So we do have to do that before we foreclose. But after that, then at that point, those are all the preliminary issues that you have to get over. So all of our collections policies and procedures do reflect those, but I just think it's important to explain whenever I'm talking about this, just because people do ask, why can't we just jump right in? So there are a lot of requirements. Your governing documents probably have requirements too on timing that you can file a lien. Typically I haven't seen one more than 90 days. So that's why this falls into this. So it's a lot. I hope everyone's saving their questions. So after we've done all this stuff, that's when we start getting into the meat of the collections. So what I'll just kind of explain, best case scenario, and I kind of already went over it, or not best case scenario, excuse me, a very simple foreclosure action or a very simple debt collection action, right? So you send the validation notice, they ignore it. Why? But they ignore it. So after 40 days, we file a lien, we send the statutory notice, and then they've continued to ignore it. So at that point, the board has authorized us to proceed with foreclosure, right? That's likely when we'd recommend foreclosure. And at that point, we do recommend that you send a final demand to the owner that says, hey, foreclosure has been authorized. It will be filed within 30 days or, whatever you want to put in there without you contacting us to pay or a payment plan or something. If nothing comes after that, then at that point on the back end, while we're waiting for that dispute period to run, we're doing the back end work, getting things ready to file the foreclosure. So I keep mentioning these procedural requirements. There are a lot of procedural requirements in Ohio, and sometimes they're county by county specific. So it really depends on where your association is. But a statewide requirement is that before you file or with your complaint for foreclosure, you file what's called a preliminary judicial report. It's title work. Basically what it is it's a certified report saying, hey, we've done this. It's done by a title company. Certified report listing all lien holders on the property. So then we have to name all of those parties. Anybody who may have a potential interest in the property, we name them as a defendant in the action, and they all have to be involved. Basically what a foreclosure is it's a marshaling of the liens. It's putting everyone on notice that has an interest in the property that we're moving forward with this, and you can be paid through proceeds pursuant to your priority. So we have to order the title work. Some counties require legal descriptions, all that stuff. So all that has to be done on the back end, but then once it's all done, we file the complaint. This is very straightforward. This does not account for, well, what if they file an answer or what if they dispute it? Very straightforward. So we file the complaint and we have to serve the complaint on every single defendant. There's certain service requirements, but once they are served, they have 28 days to file a response. And then at that point, after that time has lapsed for all parties, then we can move forward with judgment. Once the judgment's granted, that gives us our ability to order a sheriff's sale of the property. It's the purpose of a foreclosure. With our foreclosures, we 9 times out of 10 are also asking for a second count for a personal judgment against them. So we're asking for the ability to sell it at sale, a foreclosure decree, as well as a personal judgment. So a personal money judgment against the owner. And I'll explain a little bit about that later. But so once that's granted, we're able to order the sale. Depending on the county, the sheriff will, set the sale, advertise, appraise it. And then usually about 60 days after that, the sale's set, it hopefully sells. And then you have to confirm the sale and then the deed's recorded. So that was a really straightforward, easy foreclosure example, just for those of you who have not had the pleasure of going through one. But there are tons of different things that we can do. So what we have, because that is so confusing and there are so many different avenues, what we've tried to do is develop what we call roadmaps. So foreclosure roadmap, different things that can happen, bankruptcy roadmap. We have a small claims roadmap. So if any of you are clients of ours, you can access Atlas and obtain those, and that hopefully will not put you to sleep the way that explanation just did. But we just want our board members to be, if you are involved in collections, we want you to be informed about the process, just so you know what's going on. So, and I'm almost done, I promise. I could talk about this all night. There are definitely other avenues of collection other than just foreclosure, especially if the balances aren't that high, or if we know that the owner is personally collectible, maybe they're working, there's tons of different options. So another thing that we usually recommend with lower fees, so lower amounts of fees or HOAs, they're not being incurred as fast. We'll recommend doing a small claims money judgment. Same thing with the court process. Except you don't need title work, but same thing, you still have to serve them and then wait. And then there's usually either a hearing or judgments granted. But what that does is that gives you a personal money judgment against that individual for whatever amount you got that judgment for. It's good for 5 years. You can collect on it for up to 5 years. You can always renew it too after that. So you can continue to try to collect against that delinquent owner through what we call post-judgment. I'll call post-judgment efforts, bank attachments, wage garnishments. We know they're working, we can file the appropriate paperwork and get a portion of their wages, judgment liens, things like that. So we can also do debtor exams where we don't order them, the court orders them to, attend a hearing, and then we can ask them everything on the record. Where do you bank? What's your income? Just so we know what we can do to try to collect those funds. So that's another option. We also, I mentioned before, we'll get a personal judgment in the foreclosure actions too. Those are my favorite thing about that is you can continue, like I mentioned, for 5 years, you can collect on that judgment. So what typically happens is we go through the whole foreclosure process. We're stopping the bleeding of bad debt. We're getting a new owner in who's going to pay the assessments moving forward. But for whatever reason, we didn't get paid through the proceeds of the sale, or we only got a portion of it. We can still try to collect the balance owed, throughout that next 5 years, or if we renew it 10, through a bank attachment or a wage garnishment. It sounds heartless, but usually I'll let people get back on their feet after the foreclosure, and then a year or two down the road, we can try to do a bank attachment, and it's been very successful. So that does sound very heartless, but it's a really successful tool to use, and it's just something that people don't think about. We usually will do in those situations when it's a prior owner, they're gone, they've moved out, the sheriff's sale's over. We typically will offer to do those on a contingent fee agreement, contingent fee basis. So you don't have to pay the hourly fees. We don't want you to throw more good money at bad if there's no opportunity, if we can't collect. But that way, if you can collect, then that's the whole, I don't get paid unless you get paid. But at that point, if you can collect something, great. It's usually already written off. So it's just an extra added bonus. So tons of different avenues to be able to collect. As this kind of rambling 20 minutes has gone on, I'm sorry. We've kind of talked about a lot of different avenues, but the biggest thing is there are a lot of procedural things, and everything is very case by case basis, depending on your association, the particular debt involved, how you want to move forward. So it's just really important to me that our board members are educated on the process in general, and then just the actual situation of your finances, what's going on. I like to say that with the procedure, it does keep you out of it, and that's great. So that way, these people are your neighbors. Let me be the bad guy. Happy to do it. But, keeps you out of it, but I do want you to be informed about the actual process. So, you have your expectations and you understand what's going on. We do, again, I've mentioned it a little bit. If you are a client of ours, you are welcome to log into Atlas, which is our online board member portal, and you can access the roadmaps I've been discussing. You actually can access your own collections, your own association's collections accounts. You can see in real time what I see. So you can see each individual file and what the status is. That's very helpful. And then honestly, if you ever have any sort of questions or anything like that, you can always call in, you get free phone calls. But I really just think it's important that you educate yourselves, continue to keep up on that and ask the questions when you need to. I could walk you through every single type of action. I will not do it, but because honestly, people would be sleeping or signing off. But overall, I just think it's really great to, if you are in the situation where you have collections issues, it's really important to focus on the two main goals: collecting as much money as quickly as possible, and then stopping the bleeding of bad debt. Really consider that's what you're doing. That's why we're being aggressive. It's not to be a bad neighbor. You're a corporation, you're an association. You cannot pay your bills if other people do not pay them. I mean, you pay for that in either higher fees, those who are paying pay for it in higher fees to cover the cost of those who aren't paying, or deferred maintenance, or canceled contracts. And that's not your job. You're there to keep the property value up and run the association as well as you can. So I found that this process makes it much easier for you to do that with little work. We can do it for you. So with that, I am happy to answer some questions, or I don't know if Dan, Zach, you guys want to weigh in on anything?
I have a couple thoughts. By the way, thank you. It's great to see you.
You too.
I want to back up a little bit and talk about the beginning of the process. I know when your law firm handles communities, and when we get new accounts, and even with our present accounts, we ask boards to help us design a collection policy. Can you talk about the importance of that for me?
Yeah, absolutely. So when we do get on board, first of all, the collections policy and procedure, I'll explain a little bit more about that. Which is what you just asked me to do. Thanks. It's a policy and it's a procedure, right? The collections policy typically says what the assessments are, when the assessments are due. They're due the first of the month, they're late by the 10th, what the late fee is, or whenever they're late, what the late fee is. If there is non-payment, you run the risk of legal action, which could include foreclosure, money judgments. We don't give them the playbook, but we explain all of these, and we pretty much go through the declaration and cite everything that we can. That's your policy. That's what you would give out to your community. The procedure is specific, right? The procedure is attorney-client privilege. These are your instructions as a community to me as your attorney, and then your management company too, for the three parties to follow to a T. You don't share that with the community because you don't give the other team your playbook, but otherwise people are just going to be paying on that 59th day every time. You want people to pay on time. So those are the two different documents we're talking about. Dan was talking about how, when we get on board with a new client, or if, we're working together with, maybe we've had the client for a while, Elite comes on and vice versa. It's really, really important to make sure you have a set policy and procedure for multiple reasons. Number one, for ease of your job. It makes you as board members, it does take you out of it. You can still be informed, you can still know what's going on with your cases, but it takes you out of it, and that your neighbor can't come to you and say, why did you do this to me? And you can say, hey, we have a procedure. The attorney follows it. This is not an individually voted matter each time. So it eliminates that discrimination argument as well. The two defenses to a collections case are, well, I've heard a lot of them, but the two valid ones are either that's not the right amount. You put the decimal in the wrong place. I don't owe that amount, something about the number, or you're discriminating against me. Those are the two legitimate collection case defenses. And this policy and procedure, by having one in place, it's a board enacted policy. It eliminates the discrimination argument. So you're just making life easier by having all of these. And it really is an effective tool between your management company who handles your day-to-day finances. You know, they take the assessments in, they pay your bills, they do whatever else is outlined in your contract. Sorry, Dan, whatever else is in there. They deal with your finances day to day, but we are dealing with collecting them. So it really streamlines the process and helps us work with Elite to make sure we can collect as much as possible, as quickly as possible. Did I answer your question, or did I answer whatever I wanted to answer?
Yeah, you did. You're an attorney. I'm a property manager. My general feeling about collection policies in the beginning is it provides everybody a roadmap to work from and an understanding of what the process is step by step. Because I always felt that it's best to help a homeowner or get a homeowner to pay their fees sooner rather than later, right?
Absolutely. And to clarify too, that just reminded me of something that I wanted to say and forgot because I was too excited about being aggressive. This does not stop you or preclude you from entering into payment plans or working with the homeowner. You know, you can waive late fees, things like that. This just gives you that, what Dan was just saying, that roadmap. So you know what the bottom line is, and then we move forward from there. So just so everyone's aware, that's usually another question I get is, well, what if somebody needs to do a payment plan? We want to approve it. Can we not do it with the policy? No, we'll write that in there, pre-approved payment plans, and anything that we have. So if I take action against someone and they submit a payment plan proposal to me, I'm not the one accepting it. I send it to you guys. I send it to the board to make that decision. I send it to Elite to get to the board to make that decision. That's all you. I do not make those decisions on your behalf. I don't automatically foreclose. I solicit authorization to do so. I'll recommend it. I'll tell you what I think you should do in any of these cases, but.
I'm going to let everybody else chime in a minute, but this other question I'm going to ask comes up a lot from board members and other people. Generally, what makes an assessment payment in a condo in most state laws equal to a mortgage payment, where you can, in the end up filing a foreclosure if they don't pay those assessments? Does that make sense, the question, the way I'm posing it?
Yeah, I think, well, we'll see what I answer and then we'll see what you think.
Okay.
I'm an attorney. So that is a question that I get a lot, actually. I'm current on my mortgage, you can't take my house. What gives us the ability to do so is the state statutes, and frankly, your governing documents almost all have them in there as well. But it's, when the legislature created ORC 5311, which is for condos, or ORC 5312, which is for planned communities. They included it in there because it's the same way that it's your home, right? That our interest in your property is the home. You are living there. We are upkeeping your home values. If you don't pay, it's not the same as your mortgage. You're not paying towards your individual home, but you're paying towards your home values by making sure that the association can pay their bills and you're keeping property values up. That's why they included it in there. It gives us the same authority to foreclose on the lien. So the same way as you can foreclose on a mortgage. So the mortgage is a recorded document with the recorder that clouds title. It establishes the bank's ownership of the property until it's paid. They can foreclose on it. They can take it back if you don't pay. It's the same. Not the same. We can't take it back. It was never ours, but we can sell the property at share sale because you're not paying to upkeep your property values. I guess it's the best way to say that, but it's state law. And it's just, quite honestly, in my personal opinion, it's just not fair. You can't have a community association where everybody else is paying and you just decide to get the benefits of the community association, but not pay. Don't live in a community association. And then you won't after we foreclose.
Okay. Those were my two. They come up a lot,
Oh, sure.
as I'm traveling around or meeting with boards. So I thought I'd throw those two out. I will be quiet now and allow somebody else to jump in.
Well, and the next question that we have is two questions actually. First being, is there a way to collect deposits made to contractors that we decided to go with another contractor?
That depends. You're gonna hear that a lot. So no, that's more of a like a litigation style. Depends on the contract. It depends on if, although, hold on, can you ask that one more time for me? I think I'm going in a different direction. Can you ask that one more time?
Can you collect deposits back made to contractors that we decided to go with a different contractor after all?
Oh, okay. Never mind. I thought I was convincing myself I heard something else too. So that's a contracts question. It really depends on the terms of the contract. It depends on the breach. If you are able to do so because of the terms, if you decide to go somewhere else and you're not in breach and you can go after it, then we can talk about what to do, how to get it. Usually it involves a suit for breach of contract and then the court order to pay it back. But 9 times out of 10, unless it's a massive contract, a roofing contract, paving contract, something with a huge deposit, it's not worth the legal fees to fight it. I did not say that. Don't tell my partners I said that, but it's not.
The next
Don't waste your money.
The next question is, what if the community has late fees in their bylaws, but historically hasn't enforced it?
Like that, I like that question. So this happens a lot. Whether you have in your governing documents a provision that says late fees are X amount, should be charged each month, if not paid, or whether you have the boards, usually there's a provision in there that says that late fees can be charged at such reasonable rate that the board establishes by rule. And that's essentially your collection policy. So depending on what it is, either way, if you haven't enforced it in the past, it does not stop you from enforcing it in the future. I always think that you should, but I do have tons of communities that, we just don't charge late fees. We hadn't charged late fees. It doesn't mean that you are foregoing your opportunity or your right to charge them in the future, but it does make it more consistent if you do charge them as you should. And that's another good, listen to me just answering all the questions I want to answer tonight. It's been a long day. So that's another thing is if you are inconsistent with your documents, that's something that I know it's not the question that was asked, but that's something to check. Some documents will say you cannot charge more than $10 a month. And we've got associations that are charging $25, $30. Makes sense. $25 or $30 is totally reasonable. But when you have that limiting restriction in your documents, if it's expressly put in your governing documents that you can't charge more than X, that's what you have to follow. So that's something to check too. Usually with your management company is good and they know what they're doing, so you'll be fine. But something
So
to check.
I'm going to throw a curveball in between the next two questions. What happens if you've got an association that has a board turnover and they've had a collections procedure in place previously? When that new board comes in, they change it.
They're within their right to do so.
Okay.
It's a board voted policy, not community, which makes it easier for you to adopt them, but also it's a little bit of a circus when you have turnovers like that.
Yeah. The next one that we've got is, what percentage of the time do we get 100% of the past due fees and legal fees reimbursed through collections?
That's a good question. Our return rate, 100% collection on everything that on the action that we've taken. I believe at least 2 years ago, it was I think 87%. I should have looked up the more recent numbers because I'm pretty sure it's more. We've collected way more this year than we did last year. So should have looked it up. It's probably more than that, but it's and we're talking from start to finish, whether we have to go all the way through a foreclosure and then I have to attach someone's bank account 3 years later. It could be a long process, but that's always an option. And usually it's not easy to do, but there are so many creative avenues that you can take to try to collect the fees that it's doable. And honestly, by adopting I'm just gonna keep going. Can't even ask your next question. Just by adopting that policy, you may have, when you adopt this policy or when you jump on board with us or when you jump on board with a lead or whatever, or maybe you're all new to your boards and you have a delinquency problem. You've got some accounts that are thousands and thousands of dollars deep, right? And it just seems like it's impossible to collect on that. By adopting this policy and procedure, we can take care of those ones that are in deep now, but this is kind of preventing that in the future. It's easier to stop these delinquencies when they're lower amounts than it is to kind of dig you out of that hole. So that I think you're safeguarding your future by doing that. Did you even ask the question? I'm sorry, go ahead, ask your second question.
No, you did answer the question, yeah.
Oh, good.
The next one that we've got is, can we evict tenants where the owner is not paying and on their way to foreclosure?
Yeah, so it depends on your governing documents. Standard answer. It depends on your governing documents, but typically, especially in condominiums, yes. Okay, so let me back up a little bit. Condominiums, yes. Homeowners associations, very likely no, but it depends on your documents. If there is a tenant that's involved, you can do an eviction, but there has to really be rules being violated, to proceed to do an eviction on behalf of the owner. The better option is to go through foreclosure because, and I'm just saying that from a practical perspective, you do need rule violations to be able to evict the tenant on behalf of the owner. While we could say that non-payment of fees is a rule violation, really that's the owner's responsibility. We can only go after the owner, right? We can't go after the tenant. Our contract is the governing documents, the declaration, the deed that the owners accepted when they took the property or when they accepted the property. So that's our contract, is whatever's in there. It's with the titled owner, not the subcontract, which is with the tenant, between the tenant and the owner. We have to go after the owner. If the owner's really not paying, I'd say that's probably a failed argument as I'm trying to make it right now. I should be a judge. So your better option is to do a foreclosure. You're going to get that person out. It's non-payment, or you're getting that person out for non-payment. And it's typically, this doesn't seem like it is the right answer, but it's usually faster because evictions can just, between the amount of things that we would have to prove for rule violations and things like that, you could have a faster foreclosure action. And really, it's easier to get paid through foreclosure action. If you just evict the tenant, then we still have the owner that's not paying.
What happens with the tenant after you foreclose?
I'm dealing with this right now. Literally, I was sending something to a manager 20 minutes before this, trying to explain what happens. So let me read my letter. So the tenant is, if the tenant's still in there, so typically, if we know that there's a tenant there, we serve them so they're aware of the process so they can kind of get their things together. But sometimes, I'd say more than 50% of the time, we don't know. The board doesn't know, the management company doesn't know. We don't know who's in that property because they don't respond, whatever. So we don't know if it's a tenant or not. A foreclosure it's public record. You are deemed with notice once, so they are deemed with notice of the whole thing. So they were aware of it, even though they may not be. So what happens is if they're still living there, it goes all the way through the sheriff's sale process. It sells at sale. They're still there. Once it's confirmed and the deed's recorded, it is then the purchaser's responsibility to evict that tenant. So at least you don't have to do it, but it's the purchaser's responsibility. It's very rare that you file what's called a writ of restitution and kind of have to go through the process with the sheriff. It's very rare that it gets to that point. It has happened, but it's rare that it gets to that point.
It may have changed, but
it.
isn't there legal precedent after foreclosure is filed that you can force that tenant to pay their rent or their fees to the association?
You guys are just doing this presentation for me. I should have probably game planned with you before. Yes, so there is also a provision in Ohio law, and it does need to be in your documents explicitly, but there is a provision in Ohio law that says that it's a receivership is what it is. You can petition the court if somebody is in we foreclose on, sorry, Zach, I'm foreclosing on Zach. Zach has a tenant in his property. He filed the foreclosure. Zach has a tenant in the property, doesn't know about it. He continues to pay Zach. We're not seeing that money. No offense. I don't mean to make you into a bad guy, but here we are.
All about those dollars here.
So if he's getting that rent and we have proof of a lease, we are aware that there's a tenant there paying the rent, you can file what's called a motion to appoint a receiver in the court. the court can grant it. And what happens then is we approve or appoint a formal receiver. It's usually, it could be a property manager. Sometimes we have third-party attorneys do it, you know, whenever we want to pay a ton, I guess. But we appoint a physical receiver, and then that tenant is then legally required to pay whatever rent he would be paying to Zach directly to the receiver, and then the money goes to the association. So it's a good way to supplement income. They're difficult to push through sometimes, just full disclosure for everybody. They are difficult to push through just because the second the tenant gets word of it, or they, you know, they feel like they're in legal action, they just stop paying and move out. So I've had that happen several times. We've gone through the rigmarole of having a receiver appointed. I'm so excited for that first $800 check, and then the tenants moved out. So, but yes, you can do that.
So in that regard, what happens if they don't pay and they don't move out as the tenant that has that receiver in place?
Oh, that's a good question. So what will happen is the court will do basically, or we would file a motion for contempt of court. The tenant there'd be a court order saying that, I haven't had to get this far, but I've seen it happen where there's a warrant for their arrest because they're not paying per the court order. It's like child support or something like that. It rarely gets to that because that is scary, but it could happen. So really, then it's at that point, if the tenant's just not going to pay it and ignore it, my practical recommendation is let the court enforce it. If he or she gets pulled over and they have that on their record and they get arrested, great. But we can't get blood out of a rock if they're just not going to pay it. So just move forward with the foreclosure action. But luckily that hasn't happened to me.
With that, if you've got the receiver in place for a tenant, does that debt stay with the unit or with that tenant once they
the unit?
Okay.
That's a good question. Yeah. So if that tenant moves out and a new one comes in, then we'd have to update the paperwork with it. I mean, it's basically filed as though whatever tenant is in the property, not Dan Donahue as tenant to Zachary Burr, you know.
All right. The next one.
You rent Zach's house now, Dan.
I promise I'm not a slumlord. The next question is, in your experience, do you see lower delinquency from dues that are monthly, biannual, or annual?
Ooh. I've seen it all. Usually, I mean, on average, I'd say the annual fees, especially if they're, you know, not astronomical, usually have lower collection issues just because you only have to pay it once and people forget about it. And actually I have a direct message that I want to ask, from Jeff. I'm going to explain the question and then answer it because this does happen too. So people may not pay it. People may claim they never got the invoice or whatever, but eventually they do. You can get there quickly. So typically I'd say lower delinquencies, at least amounts, are definitely from those who have smaller balances, but condominium, I've found that I foreclose more on condominiums just because that debt, it incurs every month. You know, you're constantly building up. Homeowners associations are different. But to segue and again, answer whatever questions I want to answer, sorry. The question is, we have several homeowners that claim that they never received their annual assessment letter indicating when payment was due. The board assigned the late fees. Now the homeowners are stating that they weren't notified. What course of action can be done? Jeff, I get this all the time. Especially right now, because usually annual fees are late. I've taken action in like May, and now people are like, well, I never got anything. Get it all the time. The black and white answer is, this sounds very bad or mean, but it doesn't matter. There's nothing in state law that requires that we send like monthly invoices or anything like that. As long as we can verify that we sent out that original budget notice. And by verify, I just mean as long as we have a copy of it, we can say, hey, we mailed this out. Typically, unless your documents require otherwise, it's usually just ordinary US mail. That sometimes it's even electronic if you have an amendment done that. So as long as we can just show that we've sent out those budget notices, which we always can, it doesn't matter. It doesn't matter if they didn't get a late letter. from a strictly legal perspective, we still have the right to collect all of that. From the practical perspective, though, things happen. I get it. Sometimes people misplace things, stuff like that. You as a board, you can take it on a case-by-case basis. That's probably what I'd recommend, other than waiving everything for everybody. But you do have the authority to waive late fees, or you have the ability to, enter into a payment plan or something like that. So if it's something where you've assessed the late fees and people are complaining about it, you can waive the late fees in exchange for payment of the remaining balance. The only thing that we do not recommend that you do is waive any assessments. So anything that you actually have to pay your bills with, or legal fees, any fees, third-party fees that you are out that money, because then the association's taking a hit if you waive it. These people are having to pay less than everybody else. But late fees are like that cherry on top. It's not budgeted income typically. So, if somebody pays it, great, we have an extra $100 or whatever your late fees are. If somebody doesn't, it's okay if we waive them. You're not out that money. Good question.
So on a separate note to that, with waiving late fees, if you waive late fees for a homeowner that requests it, and you don't for a homeowner that doesn't, and that other homeowner somehow finds out, can they come at the community for discrimination?
So these are good. It's like
I
everything.
gotta throw the curveballs at you.
No, it's fine. I dealt with it. It's very strange. Some of these curveballs I've dealt with today, so it's a little strange. That happens all the time. They can come at you for discrimination, but the question is not if they can, sue you for that or whatever, or allege that against you. It's whether or not they'll be successful. Arguably, they didn't come to you. They didn't ask for the late fees to be waived. The board has the authority to make these business judgment decisions for the good of the community. If somebody comes to you and you believe in your capacity as a board member that they are acting in good faith, maybe they fell on hard times, you can give them that opportunity. They came to you. It's when you go to your neighbor and say, look, if you pay, I'll waive the late fees. And then it's when we offer it.
Yeah.
And then they do it. And then other people find out that we didn't offer it to, everyone else. They have to ask for it. As long as that homeowner has requested it and the board has done their due diligence, reviewed it, and voted appropriately, I don't think that it's a discrimination suit. Anyone can sue for anything. My field is wildly overpopulated. But,
That's for sure.
and they do. Everybody sues for everything. It's dumb. But whether or not you'll be successful is the question. And in that case, I don't think so.
The next one is, where can you find standard fees on the Kaman's Atlas portal?
I had another one with this. I also had a different one about the roadmaps in Atlas, and I was trying to log into Atlas to figure out where they are because I don't know. I will find out for you.
And if we can't answer your question, we have all of your emails from the registration, so we'll answer it in the next few days with an email.
Thank you.
Yep.
Yes, they say I'm trying to log in. I can't remember my password. So really firing on all cylinders today. The roadmap should be under forms, I believe, either forms or collections, but I'll let you know for sure. The standard fees for our office, it wouldn't be on Atlas. It would be in your service option. So if you're a client of ours, each year, you hire us under the service option. It's an annual contract, and on the back side of that, or the second page, since nobody has paper copies anymore, the second page of that service option, it'll explain the rates. Typically, I think we just changed them too. That's why I'm hesitating on explaining what they are. I remember what they were from like 5 years ago, and then I don't know if that's right anymore. Typically, let me see if I can find this so I don't lie to everybody. It will be on your service option. If you don't have a copy of it, call us and we can send it to you. I'm sure Elite has it or has a copy of it. We can always send one over so you can see. Let me just let everybody know, because I think we do have increased rates. Go ahead. While I'm looking for this and trying to find my Atlas password, if you want to ask another question.
The next one is, if someone in lien status makes
I'm working on
a
it.
payment, do we have to accept it, and does it stop the foreclosure process? And on top of that, do we have to resubmit a new lien?
Excellent question. This happens frequently. So if somebody's in lien status, somebody makes a partial payment. It depends on the case. Normally before we file once we file the foreclosure action, that's when I will tell you, stop accepting partial payments. I know Dan, Zach, you guys have probably heard this until probably Maggie, stop it. But so stop accepting partial payments once you're in the foreclosure action. The reason behind that is because if you accept a partial payment, it's an older, basically, it's an older defense that it's basically, hey, they accepted this. So because it's a stop. Well, if they accepted this amount, they're basically saying that the case is over. And so the court could say, hey, you accepted that balance on, even though you're claiming this balance, we're dismissing the case. Rarely happens, but it can. The other thing is if you do accept partial payments during a foreclosure action, when we file that foreclosure action, we're asking for X amount as of this date. When I move for judgment, could be 2 months down the road, could be 7 months down the road, depending on the case. When I move for judgment, I ask for the balance owed then, but if you have a savvy judge, they look at it and see, hey, you've been accepting partial payments this whole time. You're basically working out a payment plan. This case is done. That's why do not do it unless there's a board approved payment plan. But before that foreclosure, if somebody's had a lien filed against them, they make a partial payment. It's typically okay to accept it. And it depends on whether or not we'll have to update the lien prior to moving forward on the balance of the lien, the balance that was paid, and then the balance that's owed now. So a lot of times I'll file a lien for $1,000 on May 1st. The owner makes a payment gets a notice of it or finds the lien 6 months later. The balance then is, $1,600 or something like that, but then they pay $1,000. In that case, while it never reached a zero balance, arguably that lien's still good. I would likely update it just to make sure that we're protected for the full amount, but it really just depends on the amount, what's paid. Usually I recommend accepting partial payments prior to that, just because you're just getting some money in, but you do have the right to stop accepting any partial payments the second I take action. And some associations do that. So it just depends on your owners and how often they make partial payments. So good question.
The next one is, are there best practices or recommendations for the dollar amounts and frequency of late fees?
Yes. They're great questions. So typically, Ohio law says if it's not in your governing documents, it falls back on the board may set what's reasonable. A reasonable uniform late fee. So anytime a board says or what should we set our late fee at? It has to be reasonable. It has to be uniform. So reasonable based on whatever your assessment amounts are. Reasonable based on it really has to, the late fee purpose is to reflect the administrative work it takes in servicing a delinquent account, additional invoices, dealing with do not accept payments, dealing with the attorney, so your monthly late fee can't be punitive, can't be massive, but it has to reflect, it's there to reflect the additional administrative work. That's what the definition of a late fee is. So it really depends on how much your monthly assessments are, if you're charging them monthly, that kind of thing. I'd say I have a lot of associations that go up to $50. I have some that have $100, and I have had a couple courts kick it down. So you just need to know that if it is, depending on, and truthfully, it depends on what your monthly assessments are too. So it really depends on your association, but I've had some that it just gets punitive. I have some that use a percentage base, and then it's like compounding interest. And then within 2 months, your late fee is more than the monthly assessment. A court will 100% kick that out. Even if it's in your governing documents, if it says that you can do that, I have had courts throw that out 9.9 times out of 10. They do not like the punitive aspect of this.
Now, okay. The next one is, who becomes the property owner after an HOA foreclosure?
Also a good question. Depends on who purchases it, sheriff's sale. So it could be in the past, pre-COVID, whatever is happening in the world today, inflation, all this stuff. Typically what would happen is usually, at a foreclosure sale, if there's a mortgage, a lot of times the mortgage holder would just buy the property back at sale. They become the owner, which that they're having that, whatever they paid applied towards their outstanding balance, and then they can then separately sell it after they become the owner again. But what's happening more and more is, property value, sale prices are going up. It's wild. And third parties are bidding these up, investor purchasers, or just somebody that is foreclosure savvy and wants to get a property for at least 2/3 less of the actual appraised value. It's a smart opportunity. So more and more third-party purchasers are buying it. I know this was not the question that was asked. So really, whoever purchases it at sheriff sale is the new owner. Once it's confirmed, once the sale is confirmed, then title relates back to the date of the sheriff sale, equitable title. They are the owner moving forward. But yeah, more and more, we're seeing tons of third parties buy properties. Sheriff sales that, may have a minimum bid of $24,000, but they're selling for 65. Those numbers were not out of thin air. I literally just dealt with that. This is a very weird day for me. Everything that's happening, I have just done.
So
yes.
What happens if nobody purchases at the sheriff sale?
Another good question. And something else that just happened. If nobody purchases it now, Ohio law has recently changed where so there's an original sale date set and there's a minimum bid. So in a straightforward foreclosure, what the law says is whatever the appraised value is, the minimum bid for that first sale is 2/3 of that value. So if it's appraised at 90,000, then the minimum bid has to be 60, right? If it does not sell, nobody buys it for whatever reason, it's automatically now in Ohio, it's automatically reoffered for sale 2 weeks later, but with no minimum bid. Those are the ones to look for in case anybody wants some personal legal advice on investments. That it's no minimum bid. So you could get a property that's appraised at 90 grand for, if nobody else bids, 10 grand or, whatever you bid for it. So typically that is resulting in properties selling much, much more often. I do not remember the last time that I had to put up a property multiple times for sale. I do, it was 3 years ago, but in the past, that's what we would have to do. We'd have to keep ordering sale. And even if it's a 0, sometimes people don't buy it. There may be outstanding taxes that have to be paid on top of the purchase price. That's the other thing for anybody that is curious. If somebody has not paid their taxes, their county taxes. So we've got Montgomery County, if they owe 20 grand in outstanding taxes and the property goes to sheriff sale, it's a minimum bid. They bid $100, not 0. They bid $100, they win. They think they're getting a property for $100. No. So, and people need to know this because it's just a little scary. So in a sheriff sale, all the liens are marshaled. Any lien holder has to, if they don't get paid through the proceeds in order of priority, it's done. Your lien is wiped, except for court costs have to be paid and taxes have to be paid. So on top of the purchase price, if the purchase price is less than whatever is owed. So if you have court costs of $1,000, taxes of $20,000, but the property sells for $1,000, you still are going to have to pay $1,000. Good math. You're going to have to pay that additional $20 that would not be covered through the proceeds for the treasurer, right? Anything else after that is wiped free. You don't have to pay it. The liens are released. It's a clean slate, but taxes and court costs need to be paid no matter what. So they're paid out of proceeds, but if there's not enough proceeds to cover it, you have to pay that on top of it.
What happens if the purchaser cannot pay?
Oh, it happens. What happens then is typically they won't file it, or they won't. So once you bid, you put down typically a deposit. Then whoever ordered the sale is required to confirm the sale within 30 days. And then 30 days after the confirmation entry, you're required to pay the remaining balance of your purchase price or of your bid. Sometimes that doesn't happen. People don't pay it. They either decide they don't want to go through with it. They were too excited when they were making bids and realize they don't have the money, financing falls through, whatever. If they do not pay within that 30 days, typically what happens is the person that ordered the sale, so us in the situation, maybe the bank, is filing a motion to compel or a motion for contempt of court to order them to pay it. And it's the same thing with, the the receiver stuff, maybe there's going to end up being a warrant out for their arrest, whatever. But 9 times out of 10, what ends up happening is we'll work with the purchaser to say they have to forego their deposit. So if they put down $5,000, they have to let it go, and we'll vacate the sale. And then that is applied towards court costs, and we have to order a new one. It's not worth trying to pursue someone that doesn't have the money. Just cut your losses and just order a new sale and get paid that way.
So I guess that goes into a good bit of when there is a foreclosure on a property, what is the order of who gets paid and where does the association stand in that list?
It's an excellent segue into that one. So in Ohio, it's based on priority. So timing, so typically if there's a first mortgage on the property, usually they're above us, there's a first mortgage on the property, they have priority over us. Then it's all based on when your lien was filed. Any secondary lien holders. So if there is a state tax lien that was filed, but it was filed after our lien was filed, then it's based on timing. So we would be first, and then the state tax lien would be after us. 100% of the time, however, in priority, so court costs are always paid first. There are a couple counties that are screwy and flip-flop court costs and the treasurer, but court costs are always paid first. Then whatever taxes are owed, the county treasurer is paid, and then it goes in order of priority. So if there is a first mortgage, usually they're first, and then based on timing. There are certain circumstances where there is a first mortgage, but maybe we filed the foreclosure, but they failed to respond to the complaint. They failed to represent their interest in the actual case. The point of a foreclosure is to put everyone that has an interest in the property on notice, give them an opportunity to represent their interest and say, yes, we'd like to be paid from proceeds. Yes, we have an interest. This is what we'd like to do. If they don't do that, however, you can file what's called a motion for default judgment, and then that can jump you in priority. That happens way more frequently than you would think, and it's definitely a big pro to initiating your own foreclosure instead of waiting for the bank to foreclose. If you're able to default out the bank, we're first, and then their lien's just extinguished and they're, excuse my language, but SOL, and then it happens a lot.
Flip-flop that answer for a minute and talk about the association attaching to a bank foreclosure and the advantages of that to protect the association.
Oh, also a great question, and one that we have had experience with lately. So a lot of times, if it's not us that's foreclosed first, the bank forecloses on their defaulted mortgage. We will be named, or we are required to be named, whether you're an HOA or a condo, by law, you're by statute required to be named as a party, even if we don't have a lien, just by virtue of your potential interest in unpaid assessments. So even if they're current, we are required to be named as a party. So what happens, usually we're named as a party, we're served. Typically K&C is usually if you're our client, we usually recommend that we be your statutory agent, which means that we get served with all lawsuits like that. We'll get it, we'll tell you what it is, we'll recommend that you file an answer to represent your interest. A lot of our boards say, yes, please go forward and do so, but some boards do have that hesitation. Well, we don't want to spend the legal fees we don't know if we're going to collect, especially years ago when property values were property sales were much lower. There were never any proceeds available for the association. Some boards would say, no, it's not worth the legal fees for you to do so. Just don't file an answer. If we don't file an answer, we get what I was discussing earlier. You get what's called defaulted out, and you are forever forbidden to represent your interest in that property moving forward. The problem with that is if it happens and then our interest is essentially wiped from the property, if there are proceeds left over, you will not be entitled to them. So that's a very big missed opportunity. If something happens in between the bank getting judgment and a potential sale, maybe they work something out with the owner, but they don't vacate the judgment because they're waiting for months and months to have the owner complete a loss mitigation agreement or something. Typically over that time, the association's fees become delinquent, but because we did not file that answer, it is very difficult for us to say, hey, we'd actually like to do so now. You have to move to vacate the judgment. It's a costly process. Sometimes you can get lucky and the bank will agree to it. And if the court is cool, they'll let you do it. But It's a very big pain. So it's really important that you file that answer. Even if you think that there are not going to be proceeds, there likely are. I mean, Dan and I have a handful of files where there was a bankruptcy. I'm not going to talk about specifics, don't worry. There's a bankruptcy involved, and we're never going to get anything out of this. We're just waiting to write it off. But they have sold for so much that we, in so many of these cases, have the opportunity to say, hey, we filed an answer and we're next in line. Give us that. Give us the remaining balance. And
We've gotten a lot of money out of that.
Yeah, and it's happening more and more and more just over the last year. So I always encourage your boards to file the answer.
Yeah, I have, over the years, we've had several cases where, the bank goes in and refinances the mortgage without considering the association and the fees that are owed to the association. And if you filed an answer, you could go back after the bank over that refinance, right?
Absolutely, it's worth it. And if anything, even if you aren't paid through the proceeds, you're still involved in the case, we're notified of everything. If you don't file an answer, they do not have to serve you with anything else. So you can go on the docket and look for it. We can try to figure it out for you, but you're not apprised of the situation at all. You don't know if it's been worked out. You don't know who the current owner is. You have to frequently check. So even if you don't get paid through the proceeds, it's worth filing that answer just to be in that actual case. And I'm telling you what, more and more are paid through sales.
Since we've gone down the road of bankruptcies, can you talk a little bit about bankruptcies?
I shouldn't have said it.
Pre and post.
Sure.
Recording pre and post. And
yeah, so bankruptcies, if you've ever had the privilege of dealing with one as a community association, they're very frustrating. But in general, the bankruptcies that we deal with primarily as a community association are either a Chapter 13 or a Chapter 7 bankruptcy. So those are typically the types that individual consumers file. And these are the ones that we experience the most. A Chapter 13 is usually a restructuring of the debt. They're saying, hey, I have all of these creditors against the property, all of this debt that I owe against the property and myself, whatever, not just the property. I have all this debt. I want to pay it back, but I need 3 to 5 years. I need the court to appoint a bankruptcy trustee to pay the creditors accordingly. And then over that 3 to 5 years, you'll be paid whatever you're owed as a creditor, like most likely. That's a Chapter 13. There are a lot of what ifs and nuances to that. So most likely is the key phrase there. This Chapter 7 is usually a wiping the slate clean. Chapter 7 is saying, I've got all these debts, I can't pay them. You can take whatever assets I have and pay whatever you can through that. I'm walking away. Normally in a Chapter 7, a lot of times what happens in community associations especially is the debtor will indicate their intent to surrender the property to the creditors. So like I was just saying, hey, you can pay the creditors with this property, I'm walking away from it. If they do indicate that they're surrendering it, that's usually what happens. Those are much shorter. Chapter 13s are usually 3 to 5 years. It's a repayment plan over time. Chapter 7s usually are completed within 6 months and you can move forward with collection against the property. But what Dan was talking about earlier, a pre and post petition, I'm sure if you've ever had any experience with this, you've heard these words before and they're so confusing. But what happens with individuals when they file either a 7 or a 13, if somebody files for bankruptcy and they live in a community association, the second they file the second they file that bankruptcy with the court, all debt collection, everything has to stop. Whatever is owed as of that date. So if they owe $1,000 as of the date of filing, that debt collection stops, and we'll tell Dan's office to immediately put that into what's called a pre-petition account, separate and aside. We cannot take any legal action against that pre-petition account as long as the bankruptcy is in place. So that's your pre-petition account. Whatever was owed to the date of filing, that's what a pre-petition account is. If it's a Chapter 13, usually we'll file with, this is getting into the weeds, but I'm going to do it. If it's a Chapter 13, usually we'll file what's called a proof of claim. So we'll be paid that balance over the life of the plan by the trustee, but we cannot do anything else with that pre-petition debt. The other part of that is anything owed the day after that filing is done. Once that account is separated into pre-petition, that's considered, anything after that is considered your post-petition account. That in Ohio, in federal law, because it's bankruptcy, Kentucky, everywhere, the debtor is responsible to pay ongoing assessments that are incurred after the date of filing. Whether or not they pay it through the bankruptcy plan or they say they're going to pay it separately, anything that's incurred after that. So if I file March 1st, my pre-petition account is $1,000 through March or whatever, set aside. Come April 1st, I owe that assessment. And if it's late, it's late. I haven't paid it on time. So it depends on, again, the plan and what's happening with each individual case. But that post-petition account, we can take some action on. What we'll usually do if they don't pay is send a delinquency notice to their bankruptcy attorney. And then if they ignore that, which sometimes they do, then you file a motion for relief. You have to get approval from the bankruptcy court. But once you get that, then you can proceed with collection against the entirety of the property. But that's a great question about pre and post petition. It's very hard to differentiate when payments start coming in. Oh, sorry, go ahead.
Simply stated, you can treat the post petition in the normal course of business and collection, just like you treated the account before it went into bankruptcy, right?
Sort of. Yes. And yes, in generalities, yeah, typically that's what you do. They still owe it and we can proceed to collect it. It's not exactly the way that we would pre-bankruptcy, because we do need, the most we can do is send that post-petition delinquency notice before we do anything else. I can't just file a lien. I have to have relief from stay. So I have to have the court, the bankruptcy court, the bankruptcy trustee, the judge, they have to say, yes, it's okay for you to proceed with debt collection, whether it's filing a lien, sending another letter, or foreclosing. But yeah, so typically they are, in the very generality, or general speaking, yes, they are, we can treat it the same, they have to pay it. Sometimes if it's a Chapter 13, they may be paying it through the bankruptcy plan, so it may be late a couple times, but we'll tell you not to do anything because the trustee is ultimately going to pay it. Really just depends. And I could confuse you guys to the end of the world with that kind of the nuances of bankruptcy. But yeah, so pre-petition, post-petition, very different, very important that you separate them. And bankruptcy is no joke. So when in doubt, ask your attorney, ask your management company, just actually when in doubt and then there's bankruptcy, just don't try to collect it and we'll deal with it. But great question.
The next one to come in is, if a homeowner is on a payment plan and breaks it, does the foreclosure process start again or pick up where it left off?
I don't know who's asking these, but these are excellent questions. Great job, guys. So if we are in foreclosure and we enter into a board approved payment plan, depends on the timing of the actual foreclosure. So, and this is how we kind of fix this. So we file a foreclosure, they propose a payment plan, the board accepts it, right? We don't have judgment yet. We don't have a legal document that says the court agrees that you owe this much and you can foreclose if not paid. If it's pre-judgment, what I will tell my boards is you can accept the payment plan. Great. I'll encourage you to accept payment plans, but I recommend that you require that the owner execute what's called an agreed judgment entry. So we can submit it to the court. So that just gives you judgment and that protects you. So you can accept those partial payments, but if they stop, you can order a sale immediately. What an agreed judgment entry is it basically, it's a full-blown foreclosure entry. It outlines the payment plan proposal terms, just so it's there. It grants the association judgment and it says, if the owner misses a payment, we move to sale. We file a notice of default with the court and order a sale. So that way you don't have to restart the entire costly process. What happens is if you don't have that agreed judgment entry and you accept a payment plan, and depending on the payments made or the court that you're in, if they breach it, depending on the case, I may tell you, hey, we have to dismiss this and start over. So that's why it's really important to always get that judgment entry first. Agreed judgment entry, or if we get all the way to judgment, we get our traditional judgment entry and the board wants to accept a payment plan prior to ordering a sale, that's fine. You don't need an additional judgment then. then you've got your judgment protecting you with all future fees, that kind of thing. If they breach, then you just move forward with the sheriff's sale. But that's why it's so important to get, if you don't have judgment, require the owner to sign an agreed judgment entry.
All right. So the next one, what if the owner who you filed a foreclosure on has no mortgage?
I shouldn't say that's the best case scenario. That means you're first in line. So typically, as long as there's no other lien holders ahead of you, sorry, gotta get situated here, getting excited about this one. A lot of times they don't have mortgages. Some people will buy property cash, and we are the only creditor against the property other than the, unpaid taxes and whatever court costs you have to pay. If they don't, treat it the same way as you normally would. You just know for sure that once it sells at sale, you don't have to default out a mortgage holder, you are paid first. It happens all the time. And that's when people really get angry when you foreclose on them. I don't even have a mortgage. Okay. You owe us. But people, that is a very big thing. So it's happening more often. Great question.
The next one, if dues are paid annually and a homeowner goes delinquent, how long does it take to go through the entire lien process and the HOA getting their money back? Does the lender get notified that there's been a lien filed on the property, and that will or can they do anything to assist?
Also a good question. The first answer is it depends on the timing. So if you're an annual fee, first, you do need to, now that it's required by the CFPB, you have to send the validation notice first. Once it's delinquent, and then after 40 days of the dispute period has lapsed, then you can file your lien. So we're already looking at, if it's late, you're looking at a couple months before the lien even gets filed. When we get paid, really depends. Depends on if we have to move the case along, depending on the balance owed, if we're either foreclosing or doing small claims, just depends on when we get paid. Liens are good, just so I may have said it earlier, but liens are good, whether you're an HOA or a condo, they're good for 5 years. So they'll show up on title work if it's not paid. If it gets to that, you sometimes do have lower annual fee clients that they just file liens and they kind of sit on them. I still think you should move forward on stuff like that, but you want to just sit on them, and then we're getting to the 5-year mark, you just update the lien, and then that's it. So that's good. So it depends on how long. Is the mortgage holder notified? They're not notified when the lien is filed. Arguably, their notification is that it's public record. We're filing it with the county. So if they really cared to go look, that's their notification. We do not send delinquency letters to the mortgage holder. We name them in a foreclosure action because we're required to, and then they have to be legally served with that complaint. Can they do anything? Yes. Or if they catch wind of it, or maybe somebody's trying to refinance and they pick up the lien. Usually, if any of you have mortgages, and you obviously live in a planned community, you'll either have what's called at the end of your mortgage, a planned community rider or a condominium rider. It's typically like one of the last few pages of your mortgage that just says, you're part of a condominium or an HOA. You will have fees due. In the event that you don't pay them, the lender has the ability to step in on your behalf, pay it for you, and then add it back to the back end of your mortgage. So you're going to be paying more in the long run, but people usually don't care about that. So it happens a lot. Banks will contact us and they don't want to lose the property. They don't want to lose the asset to sale. It may be a current, they may be current or something like that, and they'll pay it off. They ask for payoffs all the time and pay it off. And then that's the owner's problem, paying it on the back end, but we've got the money now. I sound very heartless today. I am really not this heartless, everyone. Please know. It's been a very long day.
All right. Next one is, what if an owner refuses to pay their monthly fee, claiming the association is not fulfilling their obligations? For example, the pool is closed for months at a time, the roof is leaking, and the HOA isn't taking any actions.
Somebody was in my office listening to the things that I was doing today, the things that I was complaining about today. People do that all the time. They always say, well, I'm not going to pay because I don't like the management company you've hired. I'm not going to pay because I don't like the attorney. I'm not going to pay because there's deferred maintenance. I'm not going to pay, a litany of reasons. The bottom line is, in a foreclosure action, this is in state law, it is not a defense to say that the community association, whether condo or HOA, is not performing an obligation on their behalf. It's not a defense to not pay your fees because we're not doing something. So your obligation to pay, to pay your assessments is separate and distinct of any obligation on behalf of the HOA or the condo. So, sorry. What happens is I explain that to them in writing or on the phone. They say no, and then we just proceed.
Got it. Does the lien have an impact on credit scores, and can the HOA affect a homeowner's credit score for non-payment?
Also a good question. So we do not, just as a matter of course, we don't report to credit agencies. People always ask that. They call, they get a letter, they panic. Did you report this? No, we don't report to credit agencies. Just in case anyone's curious, number one, it is a very, very tedious process. You have to continuously update it. If you are even one decimal point or one number inverted wrong, it is a serious offense. So just in case anybody was ever wondering, we do not do so. Once a lien is filed, I believe it, because it's public record, it could impact your credit, but the lien is against the property, so it may not. Once the foreclosure is filed, then it definitely affects your credit. Just by the filing in general, anytime that's picked up on your credit report, it knocks down your score. So that's why people don't like to let it get to foreclosure, because yes, that does impact your credit then.
So this one wasn't asked here in the chat, but it was a question that was asked to me a couple weeks ago. If there is a foreclosure action being taken place and they don't have a mortgage in place, can the association buy the property and resell it?
Good question. Depends on the governing documents. So theoretically, yes, the association can. There's usually a provision that says the association can be a purchaser at sheriff's sale if you decide to order a sale and move forward with that. So check your governing documents, call your attorney to see if this is something that you'd like to do. But the biggest things to look for is there's also, so you may be able to be a purchaser, but you may also, the board may have some sort of a capital expenditure cap. They can't pay more than X amount without getting community approval. So there's a lot of different places you have to look at in your governing documents, I'd say. And there's a lot of tax implications once you do sell it. You know, once you get that income, you're supposed to be a nonprofit. So, excuse me, it may not be worth it in the end. But we do have those cases where it's not selling. This used to happen more frequently. Not selling. We just need to buy it to stop it. You can rent it out on the, excuse me, oh my gosh. And then you can sell it eventually. But check your governing documents. Sometimes you can, but depends. Usually not recommended to do it, but it's a possibility.
Can you rent it out as well before you go to sale?
You rent it out before you go to sale?
Yeah, so say the association purchases it, instead of selling it, they rent it out for 2-3 years.
Yeah.
And then go to sale.
Again, check your documents. You could probably do that, but that's going to be, again, check with your tax professional too. It's going to be additional income that you are not entitled to as a nonprofit. So, you know, you're going to pay probably a significant amount of tax on that. Check your governing documents to make sure you can have a rental. If you have a rental restriction, I do not recommend doing that. Even if you have exceptions to it, it just doesn't look good to be the exception to it if it's board owned. But yeah, all of these are definitely possibilities, but always, always, always contact your attorney and your tax professional before you decide to go down the road, just to save yourself the headache and fees.
Next one that came in is, what if the master association levies fees to a sub-association for specific common elements, but the master association fails to execute, deliver? Can the sub-association deny payment to the master, or is that the same implications as the homeowner withholding fees from the association?
So it's the reasoning behind it is the same, yes, but it's not a state law, if that makes sense. So normally we don't recommend that you withhold them if they're not doing anything. That's going to be almost a contractual dispute in the end, because it's a sub-association versus a master association, not an individual homeowner versus the association and the contract that binds the two of you, but we don't recommend that you do it just because of the massive amount of rejection that courts give that to the homeowner. The courts always side with the association. You're right. It's not a defense. If we're not doing something, you still have to pay your fees. Courts always side with that. Just if it were to get to that point, it's usually not worth that. Contact your attorney, go through some sort of mediation. Usually there's an arbitration clause, see what we can do to get it fixed. But then master subagreements are tough too, because to terminate them, you typically need 100% of both associations. And there's always that one guy that really wants it. I mean, it may be 75, it may be majority. I don't know. It depends on your documents, but usually it's very impossible to do. So try to work it out.
What rights does the sub association have against a master association if the master association isn't doing their part of the
isn't doing what they're doing? That again depends. Usually there's remedies listed in your documents. In the event the master doesn't do X, then Y. Usually arbitration is required. A lot of times between masters and subs, we see that. So that would be like either court appointed, or sometimes it says that the parties can choose a neutral arbitrator. It's like a mediation where they can kind of go in and hash it out. I think you could, I mean, theoretically you could sue if you're the sub association, the master's not doing anything. You could file a suit for injunctive relief or declaratory judgment, depending on what the issue is. But again, you guys are nonprofits. You have to think about where your money is best spent. I keep saying all these things, don't spend the legal fees. But it's true. I mean, you're a nonprofit. You need to pick your battles, and it depends on the issue. Good question.
I've got one on the top of my tongue that hasn't been submitted, and I just lost it. It's how it always goes. Does anybody else have any questions that they'd like to submit?
Is everybody still awake?
We've still got 28 participants, so we're.
Oh, good. I love to talk about this stuff. So
Sam R said they're awake.
thank you. Thanks, Sam.
Yeah.
Well, Dan, do you have anything else that you'd like to add?
Not really.
Yeah, I was like, let's stop him here.
Yeah, I had to think for a minute. The questions I asked are questions that I get regularly. And again, I'm always about management wise, trying to help or get the homeowner to pay earlier rather than later. And I'm back to the thing that we talked about in the beginning. I like plans. I like policies. I like for my communities to write collection policies so that we can all follow them, so that we all have a plan, so that the board gets what they need and we as a management company can help the homeowner. You know what I mean? So that's why after you had all that talk in the beginning, I moved back to, well, let's talk a little bit about the beginning of the process and how that plays out. And I do agree with you that homeowners associations, condos, that money is massively important, especially now because budgets are tight. Inflation and landscaping companies charging additional gas fees and things that we didn't have last year. So those then are questions. And I always think that it's very important to educate homeowners to the budget. You know, how many times do you have a homeowner come to you and say, in a master association, well, I pay my fees, so I want my card and I deserve to use the pool. Okay, but educating to the budget makes them realize that that fee only covers 1/100th of that card, right? Those fees are going to cover landscaping and roofing and reserves and all the things that go along into protecting the association.
Absolutely.
And I know you feel the same way, Maggie, that staying close to the documents, following the documents, staying within the documents, being equal with everybody only helps to strengthen a community and help a community. So
Absolutely.
And outside of that, I think you were wonderful, and thank you very much
Oh, thanks.
for your time.
This was fun. Thank you guys for letting me do this. I appreciate it. I'll do it anytime.
I remembered my question, and then we had one more come in.
There
So
you go.
mine was, when it comes to special assessments, you have a community, 75% of the community approved the special assessment. There's 25 that said, nope, we absolutely don't want it. If one of those 25% don't pay the special assessment, can you charge late fees? Can you file the lien, and can you file a foreclosure on that?
Yes. So typically, yes. So if the special assessment has been properly approved per your governing documents, I should get that tattooed on my forehead, per your documents. If it's been formally approved and somebody doesn't pay it. Okay, so it's been appropriately assessed, somebody doesn't pay it. What we recommend is when you do actually make that motion to do the formal special assessment, when the board does actually assess a special assessment, put wording in that language that says in the event of non-payment, it'll be treated like per the association's collection policy. And then yes, as long as you've got all your ducks in a row, yeah, you can foreclose, you can take typical action just as though they were not paying their ongoing assessment.
Okay. And I know we touched on this earlier. The first one that came in is best practices for collections letters and communicating with delinquent homeowners in the process that you recommend to associations.
So all of this, the policy is, once, we work with you guys and your management company to craft one for your association. Once it's adopted, we always say, send that out to your owners, send a mailing out, whether it's with another notice or whatever, do a blast. Hey, here's our new policy. It's all about information. It's informing them that this is the way it's going to be. So you put them on notice. So best practice is, first, adopt the policy. Second, send it out, put your community on notice. And then, the best way to get results is to just follow your policy. Hopefully it's an aggressive one. And over time, you'll see that more and more people will start paying at that letter stage once they see the rest of the kid. It happens a lot for people, especially when we step in and they've got a lot of delinquencies. If we are newly hired, we start taking action, people talk and, well, I can't lose my home. People just assume that because we haven't taken action in the past, we can't do anything. Then once you do, it starts a trend and it's a little scary for people. So I think just putting the information out there, letting your owners know not what the procedure is, but what the policy is. And then as far as notification requirements to them, we follow what's in your documents and state law, unless your governing documents specifically say that it has to be certified mail. It's just ordinary mail communication, and that's all we have to do.
And then the last one that's come in is collections agencies that you recommend. You get to plug a little bit.
Sorry, me. This is politically a difficult question to answer. So there are collections agencies. I'm not even going to name names, but so there are agencies that do this as a matter of course. It's the I don't get paid unless you get paid. It's like, this is very hard to answer. I don't like that you asked this question. Personally, I don't recommend using them. The point being is it makes an accounting nightmare, because if it's I don't get paid unless you get paid, they send the bill to an owner for your assessments are monthly $100. They send the owner $100. The owner actually pays in response. Well, then you're just getting, if it's a 25% contingent fee, you're just getting $75. And then you're losing that other 25 that's going to the collection of it. When you don't use a collections agency, when you use a legal team, typically the legal fees are assessed back to the account. The association is invoiced them, they're paid by the association, but then they're assessed back to those individual accounts for the offending homeowner, and they're not considered paid in full until they pay everything. So in the long haul, it's you get everything back normally. In the just general accounting standpoint, sometimes it gets really hard, and you guys may be able to speak to this more than I can if you ever utilize one, but it's really hard to figure out how to apply those payments. I mean, if you just apply $75 of that to my account, it looks like I'm running a $25 delinquency when I paid $100. I paid what you said I had to pay. And then you get into all these disputes. It's a fair debt nightmare. It's very, very difficult to get yourself out of a situation like that. That being said, I have no other comments about them, just me personally, not a professional opinion. I just don't think that they do the best for your association.
So going into how working with a legal team, we bill back the legal fees and the late fees to that homeowner. What if you have a homeowner who refuses to pay the late fees and legal fees?
Well, if it happens a lot.
You can continue to charge late fees to the late fees and onto the legal fees.
Yeah, so these are typically, I like to kind of look at these on a case by case basis when this happens, because it does happen. They'll get my letter. It'll be, I'll say they owe $1,000 and my letter's $115. So I say, hey, you owe $1,115, and they send in $1,000. And then there's a late fee next month because they haven't paid my legal fee. And then they pay the ongoing assessment, but they don't pay the next one. So they're just riding up late fees and legal fees. It does happen. I think at that time, before we proceed, we can't really foreclose on accounts like that. If somebody's paying, it makes it very difficult for the courts to allow us to take a home or obtain a judgment against someone who's paying their assessments, even though the application of payments in the statute clearly says that any payments they make will first be applied to, everything before those assessments. From a practical standpoint, and in my experience in the courts typically don't follow what's in that. So we take it on a case by case basis. If it's something, and I'm saying this now, and everybody that's a client of mine is probably going to write it down and help me to it, but I'm happy to help. If it gets to that point where it's not worth you fighting to collect legal fees and late fees on just a legal fee, I'll look at the account. I will offer to waive those so the association doesn't have to pay them. We can write it off, and that way you're not out assessments.
Let me write that down real quick.
Yeah, I know. So everybody probably should. We're talking minimal, like in the beginning. If I send a collection letter, they don't pay it. I mean, I'll work with you guys. It's difficult to collect on an account like that. From a legal perspective, you can continue to do so. You can continue to do so. You can continue to assess a late fee every month because it's really on any unpaid balance whatsoever. You can do that, but it just gets harder and harder to collect if they continue to be difficult and dispute. And at some point you need to look at it and think, is this worth the additional time and effort we're spending? When I don't like to let people win like that, but sometimes you do have to make the business decision. Is this worth your time?
Yeah. All right. Is there any last questions that anybody wants to ask? Speak now or forever hold your peace.
If not, while we're waiting, thank you all so much for listening to this whole thing and for the opportunity to sit here and talk about something I really like to do, which makes me a huge nerd, but loved it. I really, really appreciate it. So if anybody has any questions or follow-ups, feel free to reach out and I'm happy to help. And sometime I will find out where those forms are on Atlas and I'll let you guys know.
So
I'm going to figure out my password.
well, you do really appreciate everybody participating tonight. If you have any questions for us that you think about afterwards, email them in and we will get answers back out to you guys. Thank you, Maggie, for joining us. We really do appreciate you spending the time and talking us all through this. I know we've thrown some curveballs at you. So
My pleasure.
Thank everybody so much and have a wonderful rest of your evening.
Thank you.